Hello, and welcome to this edition of The Scales of Justice. I'm District Attorney Tim Cruz, and I am the District Attorney of Plymouth County. Joining me today is my special guest, Assistant District Attorney Barbara Isola. Barbara is an Assistant District Attorney within my office, and she oversees the grand jury and has worked for the Plymouth County DA's office for approximately 31 years. Barbara is a graduate of Hunter College, where she received her bachelor's degree in nursing and is a graduate of the University of San Francisco Law School. On today's episode, we're going to discuss the grand jury. 2015 marks the 800th year that the grand jury has been in existence. The first instance of the grand jury dates all the way back to King Henry II of England's Assizes of Clarendon Act of 1166, which transformed English law. So we're going to get right off with it right now. I'm going to ask Barbara to kick it off. Barbara, what is the purpose of the grand jury?
Well, first of all, Tim, thanks so much for having me here. It's a topic that I'm so passionate about, and I think that people need to know that the purpose of the grand jury is to investigate crimes and to develop and to find probable cause, to find out whether or not a crime was committed, and is this the person who committed the crime. So it's a way for us in the government to have a shield between us and the people so that we can show that we're doing fair and impartial investigations.
So we use the grand jury almost as a buffer to make sure that cases are going to go through the people first before we make a determination as to whether that certain case will go to, in Massachusetts, Superior Court.
That's exactly right, Tim. So every 3 months in Plymouth County, we impanel a grand jury of 23 people. Now, those 23 people don't sit every day in the 3 months, but it's a real big commitment that folks have once they're seated on the grand jury. They sit 2 days a week, and we need 13 people to have a quorum, and then 12 of those people, whether there's the whole 23 or 13, need to vote in order to have an indictment.
And I know that things have been getting very busy in our county over the last few years because we used to only have one seating of the grand jury per week, and now we have two, which shows really how busy and growing our county is.
That's right, Tim. And really what the 2 days allows us to do is to give the grand jurors somewhat of a break during the day, because for a while these folks were sitting from 9 o'clock in the morning till sometimes 5:30, 6 o'clock at night with minimal breaks. They're hearing very serious crimes.
Right, because those are all the Superior Court jurisdiction cases, the murders, the rape cases, the drug trafficking cases, things such as that. Those are really exclusively the only cases that we end up handling up in Superior Court.
That's right, Tim.
Okay. Now, what's the difference between a grand jury and a regular jury? What's the burden of proof?
Well, the difference is that when we take a case to trial as assistant DAs, we have to prove each and every element of the crime to the standard of beyond a reasonable doubt. And as you know, we do that every single day in the courtrooms in Superior Court. For grand jury, our standard is probable cause, and it's essentially the same standard that our police officers use in effecting arrests. So is it more likely than not that two things happen? One, was a crime committed, first of all, and second of all, is this the person who more likely than not committed the crime?
Now, we also have rules of evidence that we have to abide by in our regular jury trials. How do they differ from the rules of evidence that you deal with at the grand jury level?
They differ vastly. At grand jury, we're allowed to present what's called hearsay evidence. So that allows us to, in some cases, bring in a police officer in lieu of a victim to say what that person told the officer. We don't do that all the time. Sometimes we bring people in to tell us what they saw. Sometimes the police don't have an opportunity to speak to people at the scene, so we'll use the grand jury to ask people to come in, subpoena them in, to tell the grand jurors what they witnessed.
And just for our viewers, our hearsay statement is an out-of-court statement being offered for the truth of the matter asserted, like you said. So if somebody saw something and then they told somebody, normally at a real trial, the person that was told could not say that John Doe told me they saw the accident. We'd have to bring in John Doe to say exactly what they saw. But
right.
But at the grand jury, we can use that hearsay.
Right, and that allows us, first of all, the grand jury hearings are pretty quick. So maybe a drug case that might take anywhere from a half hour to 45 minutes to present to the grand jury might be a full day trial in Superior Court, and that's because of the different rules of evidence.
And you already said there's 23 grand jurors, but is that the normal amount? Could there be more? Could there be less? How does that work?
No, it's 23, but as I said, we only need 13 present to work. If we have less than 13 for some reason, we do not have a quorum and we can't proceed.
Okay. So then without that 13 number, you have to kick everything over that day to another day to make sure that happens.
Tim, I have to tell you, I'm very fortunate I've been in the office for almost 31 years, doing grand jury for 26, and it's never happened. Now, I don't want to jinx myself.
That's really impressive. I mean, the people show up, the jurors are really committed to that.
I can't even tell you how committed they are. Generally speaking, we have anywhere from 20 to 23 people present. The people come, they're committed, they take this very seriously, and they leave after the 3 months with an entirely new perspective on what we do in the office and what the world is in Plymouth County.
And you let them, they certainly understand that what we do is not like Law and Order or CSI, that there's a lot of real world things that have to be done with on a daily basis. And a lot of our cases are really done with old-fashioned police work and a lot of good hard work by our prosecutors working in conjunction with the local law enforcement.
Yeah, we're so fortunate. We have so many wonderful members of our team in bringing these cases to the grand jury. And it's just amazing to me to see how people want to come here and listen and absorb the law and do the right thing.
Now, if there's a presentation made to the grand jury, what comes out on the other end? How do we, once we put our evidence into the grand jury and they make a determination which way they're going to go, what can they resolve it with?
Well, they'll vote for an indictment. So what we do is we'll present them with certain crimes that we believe we've proved, but with probable cause. And we'll give them, in Plymouth County, we have green pieces of paper, which are indictments, no magic to the color. And they actually look at the indictment, and it has the law written on it, and they make a determination. They vote each and every indictment by a vote and determine whether or not they're going to indict it. It's also called a true bill. If we don't have the requisite 12 people voting for an indictment, then it's called a no bill.
And what's the numbers? Is it just a majority, or is it 75%? What are the numbers that you have to have for that?
You need to have 12 people voting for indictment, no matter how few are there. So as long as there's 13 people, we need 12. That number never changes. So if there's 23 people, we still need 12.
Okay. Well, witnesses are brought to the grand jury. How are they notified when they have to show up versus, because there's so many things going on, so many different days, is it treated like a regular trial?
Well, what we do is we send out subpoenas, which are basically orders to appear in front of the grand jury. So we send them out by mail. If we need to get someone in very quickly, we'll ask a police officer to go and hand deliver it. We have victim advocates in our office who are extremely helpful in making sure people understand when they need to appear, to assist with transportation if people don't have that transportation at their disposal. So we have so many people, so many different people, the administrative staff sending out those indictments, fielding phone calls to make sure that people show up, and they do.
And, so once you get your grand jury seated that day and the witnesses show up, what's the procedure? How do you get going? How does it get moving forward in that individual case?
Well, it's interesting because I know you come down to our office sometimes when we're doing grand jury, and sometimes it looks like controlled chaos because we need to speak to our witnesses beforehand. And I tell the grand jurors that I'm going to speak to my witnesses to line them up, to figure out where we're going with the case. And then we start prioritizing what case needs to go. Is there someone who has another commitment? So we go in that regard. So we just get a lineup and we start moving, and it works. like clockwork most of the time.
Well, I know you guys have been doing a great job down there with the grand jury for all that time, because all of our serious cases end up going through the grand jury, and they must be dealt with. And as the people here know, in our county, we have in Plymouth County in any given year 20,000 criminal cases. We have an awful lot of work for a small number of lawyers, and everybody really does a great job, including you at the grand jury. But I think this is probably a good place for us to take a brief break. When we come back, I'd like to further discuss the use of the grand jury for their other function, the investigatory function. So thank you right now for joining us on the Scales of Justice, and we'll be right back.
We have a big problem, and we need your help.
It's happening on college campuses, at bars, at parties, even in high schools.
It's happening to our sisters and our daughters,
our wives and our friends.
It's called sexual assault, and it has to stop.
We have to stop it. So listen up.
If she doesn't consent, or if she can't consent, it's rape, it's assault.
It's a crime. It's wrong.
If I saw it happening, I was taught you have to do something about it.
If I saw it happening, I speak up.
If I saw it happening, I'd never blame her. I'd help her.
Because I don't want to be a part of the problem.
I want to be a part of the solution.
We need all of you to be part of the solution. This is about respect. It's about responsibility.
It's up to all of us to put an end to sexual assault. And that starts with you.
Because one is too many.
Welcome back to the Scales of Justice. Joining me today is Assistant District Attorney Barbara Isola. Before the break, we talked about the grand jury and its accusatory function. Now I'd like to further discuss the grand jury's investigatory function. So we talked a little bit about the first one, Barbara. Now we're going to talk about the investigatory function of the grand jury. Can you explain to our viewers what that's all about?
Sure. So sometimes we have a crime that's been committed, but we don't know, who done it. And we'll use the grand jury to start bringing witnesses in to see what they know about the crime. We might send out subpoenas to various institutions, whether it be phone companies or banks, depending on what the crime is, to gather that evidence, hospital records. And we'll use the grand jury to assist the police in their function of investigating a crime. We have one advantage at the grand jury that police officers don't have, and that is we have subpoena power. So whereas someone might be able to say to a police officer, no, I don't wish to speak to you, once they come to the grand jury, they really need to appear. Now, there are certain things that witnesses can assert privileges against self-incrimination and have other privileges that they can assert which would preclude them from testifying before the grand jury. But generally speaking, once someone's subpoenaed, they need to show up.
And another key aspect of getting somebody to the grand jury and getting them especially quick, especially after a violent, say a homicide case has occurred, is we want to certainly get them in under oath and lock their testimony in, because unfortunately in our business, especially in certain portions of our county, people will tell us one thing on one day and may change their stories as time progresses closer to trial. So it's incredibly important to lock them in right at the outset.
Right, Tim. And you bring up a good point. When someone comes to the grand jury as opposed to just speaking to the police, they're under oath. So at that point, they fully understand that they need to tell the truth, for the pains and penalties of perjury.
Right.
So that's really a very impactful fact when we tell people that. And occasionally people will say, are you threatening me with perjury? And I always try to explain to them that in no way are we threatening them. We just want them to understand what the implications are for them going into the grand jury and perhaps not being truthful under oath.
Now, if I was subpoenaed as a witness to show up at the grand jury, and as we know, many people are not happy to get that subpoena. They don't want to be there, they don't want to testify. What's my rights as a witness regarding whether or not I have a right to legal counsel?
Well, you do have a right to bring an attorney to the grand jury, but the rules of criminal procedure are very clear about what that attorney's role is. So, for example, you can't say I have an attorney so I can't come and just string that along, because the rules basically say that we at the prosecution are under no obligation to hold up our proceeding for that attorney. Now, of course, we give professional courtesy to, members of the defense bar or, fellow attorneys if they have another case in another court. We do whatever we can to work with them, but we can't allow someone to use that as leverage to keep continuing the case. Also, the attorney can go in the grand jury room with their client, and generally speaking, they understand that the rules are such that that attorney may not address the assistant district attorney putting the case in, nor may they address the grand jury. I'll say to the attorneys beforehand, how would you like to communicate with your client if there's an issue? So we try to, there's a collegiality there, Tim, and we try to get that squared away before they go in.
And once at the investigatory level, once all the evidence is presented, what happens at that point, once you finish presenting that evidence?
Well, of course, we, the assistant DAs and the police team, will examine all of the evidence and make a determination as to what, if any, indictments we want to present to the grand jury. And then we'll present them to the grand jury, and they'll vote. They'll determine whether or not we met our burden of proof. So sometimes what we do is there are no charges that come out, and the case will just lay dormant or maybe go to another grand jury until another piece of evidence surfaces.
Right. So the investigation may not at that time lead to an indictment on someone regarding a case, but it could certainly be the foundation later on down the road, once you put that piece of the puzzle in.
That's right, Tim. And as you know, we've had some cases that have been indicted after 10 years, of investigation from 10 years ago, that there was a new piece of evidence that came forward, and we were able to take that old presentation, give it to another grand jury, and proceed forward.
Yeah, and the older cases and the colder cases, as they say, they bring a whole different level of work that has to be done, because in light of the fact that many of the cases that we look at, and I know when I became DA, we looked at more than 100 unsolved homicides here in Plymouth County, a lot of that evidence doesn't exist. Or at the time, nobody knew that it was important to take a cigarette butt or to take perhaps a blood smear off a broken window back in the 70s or 80s. Nobody heard about the concept of DNA. So it really creates a challenge, I think, for current law enforcement to deal with older cases when you look at an old black and white photo and say, gee, I wish I had that cigarette butt. I wish I had that blood smear, because nobody knew back then to hold on to it.
It's true. It really is challenging. And the other thing that people need to know is that when someone goes into the grand jury, their testimony is recorded by a stenographer. So one of the advantages from those old cases is we have those transcripts. So we could go back to those transcripts to see what people testified to back 10, 15 years ago. Right. But you're right, with the forensic evidence, it's really challenging.
And you can use those also back at the same time. You can use those statements that were taken under oath. Say a crime occurred and it was a relatively heinous crime. We bring somebody into the grand jury, they testify to information A, and then 2 years goes by and the case is on for trial, and now they say, I don't recall saying that, or they'll say that you forced them to say something, which is why it's so important to have those tapes, those stenographic proceedings, and why it's so important for us to have those documents, because we can use those actually in the trial itself if somebody ends up flipping on us, for lack of a better word, when we do try that case.
Sure. I mean, the grand jury transcripts are used to impeach witnesses all the time. And it's important to note that defense counsel, as part of our discovery process, receive a full set of grand jury testimonies, so they know what every person testified to at the grand jury. So they use it to impeach sometimes our police officers. Right. And you know, it's human nature that sometimes things come in a little differently. You know, you just hope that it's never something material.
Right. And like you said, in our discovery obligations, there really is no mystery witness coming like in a Perry Mason television show, pretty much everybody has the information that they need going forward because of our obligations to turn over exculpatory evidence, and also for the fact that the defendant, for the most part, is usually ordered to provide over expert testimony to us, at least prior to the testimony or during the testimony of their expert.
That's right. There's no gotchas.
Yeah.
There really aren't.
Great. All right. Well, I thank you so much for coming in today and putting a little light on the grand jury process, because it is also, on top of all of this, a secret proceeding. And
right. And this is interesting, Tim, if I may. Just, it's secret while it's going on. And sometimes that confuses folks, because once the indictments happen, then they become public.
Okay. Well, that concludes this episode of the Scales of Justice. I'd like to again thank Assistant District Attorney Barbara Isola for joining me today as my guest. And once again, thank you for joining us. And I look forward to seeing you once again on the next episode of Scales of Justice.
Today we're standing in the map room, which is located on the ground floor, just opposite the elevator up to the president's private quarters. This room was used in the early 20th century as a billiard room in the Wilson administration. By the time the Roosevelts were here in the 1930s, it was called the trophy room. It was a place where gifts were received and set around on bookshelves and tabletops. Right after the attack on Pearl Harbor on December 7, 1941, planning went into way to give the president a situation room, a room that was then called the map room, a place where he could consult secret documents and communiques from the fronts. This room was selected because it was very close to that elevator and allowed the president to come down in his wheelchair, roll across the hall, and come into this private space. It in fact was reserved for the president and a select group of military officers who staffed the room. It was not open to the Secret Service. They had to stay outside and protect the president from outside the door, but it was not open to just anybody to come in. One of his regular visitors, however, was Winston Churchill, who came to the White House shortly after Pearl Harbor Day. I was here at Christmas time in 1941, had a room in his war bunker where he had a series of maps that was used for the same purpose, just to study the course of the war. In this particular room, the desks were placed in the center of the room so that maps could be put on artificial walls around the outside of the room to which maps could easily be attached. And the president could then roll his wheelchair between the desks and the maps to study the theaters of the war. This particular room now has two items that are associated with the map room. There is a map. It was produced in this room right at the end of the Roosevelt administration. So he had gone to Warm Springs, Georgia, to the Little White House and had a stroke and passed away there. And this map was being produced. It was the last German positions as of April, May of 1945. It in fact is simply a National Geographic map of Europe with a plastic overlay, and then they taped on shapes around spaces that were still occupied by the German forces and those that had to a large extent been bypassed by both United States, British and Russian troops advancing across Europe. Below that map is a wonderful watercolor that was drawn by one of the White House calligraphers, William Gemmell, to the recollections of George Elsey, who was a naval officer in this room during the war, where he described how the desks were positioned, what the maps looked like, what the president would look like in his wheelchair, what the telephone looked like. After it's being used as the map room, this room has had other uses in more recent times. In fact, it was the original curator's office. When Mrs. Kennedy created my position. In the Johnson administration, it was used partly by the doctor's office next door and partly by the Secret Service. But then in 1970, it became a more formal but private drawing room here in the house. It was furnished in the Chippendale style to represent the late 18th century styles that George Washington and John Adams would have known in their houses in New York and Philadelphia. And it includes some maps on the wall of one that was surveyed by Thomas Jefferson's father of Maryland and Virginia, and others of the city of Washington, which includes some images of the White House. But it retains its name, the map room, because of that moment in time when, during World War II, it was part of the most vital and central planning of the war effort on behalf of President Roosevelt living here in the house.